When she first got there, she walked to her team and had developed this juice that was part vegetable, part fruit, and had, you know, and they're like, and they spent, you know, hundreds of millions of dollars on that. And they're like, oh, we're not going to
Good morning, everyone. We will get started so that we can honor our commitment to the public to be back in open session at 9 and try to get some of you out of here for earlier flights. So with that, we continue to call the roll.
Broughton. Here. Chen. Fox.
Here.
LeBron. Here. Lee. Manning. Here. Mendoza. Here. Pertula. Selig.
Here. He's here. Just getting back.
Spector. Stallings.
Here.
Steinbrecher.
Here.
Stevens.
Did not go to the after party. Here. Just saying.
We have 5 cases on our closed session discussion. We will return to open session at 9. We've got 5 cases on our closed session calendar today for reports from council. We will get back into open session promptly at 9. We may need a small closed session at the end of the day to pick up anything we don't cover in this half hour. And there may be some developments on one of the cases in a briefing that council's going to do with our litigation liaisons at lunch. And if so, we'll have another brief closed session at the end of the day to pick that up. So with that, is there, waiting for the folks who couldn't be here to take their leave. Although I think even in their presence, I can ask, is there any discussion of the closed session minutes? Lacking such discussion, they shall be deemed approved. Go ahead. We're still
But I can fit a minute. I just have to know kind of when.
Yeah, sure.
I mean, I was yeah.
Good morning, everyone. We are returning to open session at 9 o'clock as promised, and we will start, as we always do, with a roll call. And while our secretary is getting to his place, I've been asked to remind all of you to speak into the mics and to keep the mics close to your mouths so that the folks who are on the internet can actually follow what you have to say.
Broughton,
Here.
Chen, Fox,
Here.
LeBron, here, Lee, Manning, here, Mendoza, here, Bertula,
Here.
Selig,
Here.
Spector, here, Stallings, Steinbrecher,
Here.
Stevens.
Here.
Okay, we have a quorum. This is the opportunity for public comment to address the board. If there's anyone who would like to address the board, please come to the table and use that microphone. Push the button, you'll see a little red light on, and you'll want to keep your mouth close to the mic to be heard. Welcome. You have 3 minutes.
My name is Livia Romovic. I have been auditing government agencies in the state of California for the past 6 years. It's like an epidemic of government corruption. It's not that we don't pay enough taxes or that we have fancy services. It's that they're stealing our money. They're embezzling it, they're throwing it away, they're giving it away. When I first started auditing, I couldn't find any additional duty of care on city attorneys or any council that is over government agencies. So I called this a board and I asked, where are your laws regulating government attorneys? And I was told we don't have any. There are no additional duty of care on government attorneys. There has to be additional duty of care on government attorneys. Just one example, the city of Beaumont. There is $400 million missing out of the city of Beaumont. $300 million of it came out of municipal bonds. James Gregg, an attorney, set up a company called General Government Management Services, which was a company that acquired bonds. And so he was also the risk manager for the city of Beaumont. So he received a $250,000 contract, and he had another company that was making profit off the bonds. Then he started his own insurance company, Ermac, and he was the risk manager. He was selling them insurance as a self-insured city, which they never qualified for because they had no money, they've stolen it all. And he had this other company on the side. The SEC has already thrown him out of the bond industry. The city manager has been permanently banned from the bond market. The city of Beaumont has a cease and desist order on it from the SEC. Cease and desist from forging government documents. They were supposed to get a private consultant to come in that wasn't associated with anyone else. The city got an out-of-state lawyer. Yes, not licensed in the state of California. The city is a catastrophe, but it keeps coming back to these lawyers having some idea that they could commit crimes, commit state and federal laws. They are embezzling documents there. The former city manager, Joe Akufi, has already lost his license. He's been indicted by the state, not the feds. I am requesting that this board establish additional duty of care on government attorneys. Somebody has to be watching them. There has to be additional. It can't be the honor system. It just doesn't work anymore. Thank you.
Thank you. Do we have anyone else from the public who wishes to address the board at this time? And I don't know that Joe has lost his license yet, but he's the one defendant in that corruption case who has not pled guilty, and he's going to trial.
He lost his license January
Did he?
2015, yeah,
Okay.
or 2016, something like that. I forget.
Pretty sad circumstance out there.
Thank you.
Thank you for coming. Okay, on our consent calendar, we have 4 sets of minutes. Is there any desire to discuss the consent calendar, or may I deem it approved? It is deemed approved. Now we turn to my oral report. Just have a couple things I wanted to talk about. One is that I intended yesterday to observe that it was International Women's Day. and failed to, but I'll mention it today instead. And one of the ways that we at the bar can observe that day is to note the successes that we've had to date at developing the talent of our female management team and to create and maintain a diverse management team. And I'm pleased to sit between these two talented women and to observe that we've been successful in ways that others have not. You have heard me in board meetings talking about our budget. You've heard Leah talking about our budget and the challenges that we face when our fees have been flat for 20 years. There's been growth in the number of lawyers at just less than 2% over that time. And our labor costs alone, which are 70% of our general costs, have been north of 2% over that time. And eventually these lines cross in an unfortunate way. And so we will continue to focus on saving money where we can and building a case for a fee increase when there is a political environment that will allow it. You are aware that California has a substantial delegation to the American Bar Association, and that those delegates are appointed by this board, and that we've had some dialogue about whether we should continue in that role or whether we should encourage the ABA to amend its constitution to place those appointments elsewhere. And our management team believes that the ABA plays regulatory roles that are relevant to our work, and that we should continue to engage with the ABA, and that we should find ways to make our delegation better resources for us in engaging the aspects of the ABA that are relevant to our regulatory, public protection, and diversity missions. And staff has started that dialogue with the ABA delegation. And since some of you know those folks and rub shoulders with them from time to time, I wanted you to be aware that that dialogue was underway.
So we're keeping those appointments.
We are, only the ABA gets to make that decision. But at this point, we are not urging them to make a change. We think there's a relationship that we wish to maintain, and so we're going to advocate to stay in the role that we're in. You will recall that at the beginning of my term, we added Friday video conference meetings in the months when we don't have face-to-face meetings. And I'm pleased to say that it's worked pretty well from my perspective, because we have not made our poor harried staff try to identify a date when a quorum of us could be at the same place at the same time to do a special meeting. But now we get the benefits of having had a steady supply of meetings. Staff doesn't need an April meeting, and they kind of need a break from the agenda pace. So you can now clear that April 6th date from your calendar. We will next meet for our 2-day meeting in May. You have seen from time to time this sprawling collection of disorganized policies that we call our board book. The board book is not a very fit tool for the roles it's supposed to play, primarily because it was neglected, I think. It was not a day-to-day lively part of the bar, and so all of its internal inconsistencies and lack of connections were allowed to develop and fester. This management team is trying to take the board's policy role seriously, and every time they bring a matter to us for action, they discover 3 inconsistent board book policies on topic and wonder what they're supposed to do with that. Leah and I discussed 2 distinct possibilities. One is just to repeal the darn thing and rebuild it from scratch, which we call zero-based budgeting. I was a little concerned about that approach because you don't really know what you don't know. Instead, what I've encouraged Leah and her team to do is, if they want to take an action that is inconsistent with something in the board book, just tell us about the inconsistency. One of the virtues of our form of governance is that everything we do by motion has equal dignity with everything else we do by motion. We don't have ordinances which require 2 readings to repeal or resolutions or anything else. So we can suspend our rules just by saying so. So I think if we do it that way, which is that each time there's a tension, or 4 or 5 or 6 competing tensions, with something that makes sense to do, and what our board book says, staff will flag it for us, and we'll do what we need to do, and then over time we'll rebuild the book and make it a more useful tool. That's our provisional understanding. I'm not sure the league is completely convinced that this is the best use of her team's resources. I'm not sure that I am either. We're going to try this out and see what we get to. But the good news about this is that our management team is taking the policy-making role of the board seriously and wants our policies to be articulate and useful. And we're going to begin to do the work to get there. So don't be too surprised if you start to see staff reports saying, notwithstanding these 3 board policies which conflict, we think you ought to do this. We have talked as a board about an affirmative program of legislative proposals. It's fairly modest for this year. You'll see some of it on the agenda today. But the legislature has its own pace, and ideas come from other sources, and therefore we are engaging with a number of bills that affect our role as we need to. And it's not my place to delve into the proposals that are on the table at the moment. Those will come to you in a report from Jennifer at some point. But the legislative season is underway. Proposals for things like mandatory pro bono or a in lieu fee have been proposed, and we will be participating in those dialogues. For those of you who want to follow the fee bill, it is AB 3249. At the moment, it is the holy grail of bar governance. It is a clean fee bill. It does nothing but extend the date and clean up some language. Whether it stays such a simple expression of confidence in our work remains to be seen. I want to note with appreciation some recent turnover on the Committee of Bar Examiners. We are grateful for the service of our departing members, most recently Lee Wallach, and we are grateful to the speaker for sending us some fresh energy. Karine Bondora from Montana has just joined CDE as its newest member. We are building our relationship with the California Lawyers Association. You're aware that their vice president is here as a liaison, and we've had a chance to meet him. If you've not, I encourage you to do so. Why don't you stand up and introduce yourself, sir?
Yes, hi, I'm Emilio Veronini of the California Lawyers Association. As Michael was so kind to introduce me, I am the vice president and the appointed liaison to this body. We're looking forward to working with you all closely. We have the same mission and the same objectives of furthering the practice of law and protecting consumers. So if any of you have any ideas or any issues that you wish to bring to our attention, please feel free to contact me or the other officers of our organization. Thank you.
We are continuing our dialogue with CLA at every level, staff to staff, leaders to leaders, and we look forward to their success. If you have joined a section, you have joined the CLA. If you've not joined a section, I encourage you to do so. Last and most certainly not least, you will note that there's an agenda item for us today that has to do with Pat Lee's decision to retire from full-time commitment to the work that she does for the bar. Pat could not be here today, and therefore we don't have a pretty version of her resolution yet, but I have a mock-up of it. And I want to select from this resolution some of her accomplishments to honor the work that she's done for the bar and for the people of California for some 30 years, 24 here. So whereas after nearly 24 years dedicated to furthering justice and diversity, whereas Pat Lee has dedicated her entire professional career to legal services and diversity in the legal profession, whereas Pat was the first director of the State Bar of California's Office of Legal Services, she implemented legislation which created the Interest on the Lawyers Trust Accounts program, which has generated almost $400 million for legal services since its inception in 1984. She was recognized by the State Bar and received the 2014 Spirit of Excellence Award from the ABA Commission on Racial and Ethnic Diversity in the Profession. She has developed some of the most vital and creative programs in legal diversity in the country, including pipeline programs for girls, women, people of color, and programs that span from early education through adulthood. She was admitted to the San Mateo County Women's Hall of Fame in 2007. She has been the heart, the soul, and the conscience of the Council on Access and Fairness. So therefore, I ask for a motion and a second that we might resolve that the State Board of Trustees and the leadership of the State Bar of California express their deepest appreciation to Patricia Lee for her invaluable contributions to the State Bar of California.
So moved.
Second.
Any discussion? May we substitute the roll call? Congratulations, Pat. Godspeed. Did you get the motion and second? It's Joanna and Jim. I think we turn that to your report.
I'm going to use my time today to share with all of you a little bit about the meetings I've been having with staff over the last few weeks. I've been meeting with small groups of staff, usually around 20, and I'm going to eventually get through the entirety of our staff in this manner. And the purpose of these meetings is for me to share what I did during my formal executive director transition period. I'm also giving staff a view of my 2018 performance plan that will be used to do my evaluation later this year. And in addition, I'm sharing with them the fact that that evaluation will include a 360-degree component so that they will all have an opportunity to weigh in on my performance. I'm closing the meetings out by giving an overview of the things we have to get done in 2018 to advance the strategic plan. And this is a long list, and just to name a few so that the board gets the same information in the same manner as our staff is getting it. We have the governance and the public interest task force sub-entity review that needs to be completed by September of this year. A statutory report on the Client Security Fund, which the board will consider today, due next week. We've got to complete the workload study and develop a funding methodology pursuant to that study. The board heard about that workload study yesterday. Case prioritization and OCTC will be implemented, as again, the board heard yesterday. We've got to implement and evaluate case prioritization this year. Adopt new metrics for our discipline system, again, discussed with the board yesterday. Deploy the Odyssey case management system for the Office of Chief Trial Counsel, State Bar Court, and the Office of Probation. That deployment will take place in the fall. Launch the admissions information management system, which, as Andrew reported yesterday and Amy, we have signed contracts to begin that process. Initiate a California job analysis. For the first time in our state's history of developing and administering a bar exam, we will be conducting a job analysis this year. We are implementing a host of employee engagement initiatives, and this I really want to highlight for the board. One of the things I'm sharing with staff as I'm having these meetings is some high-level feedback that I got from each of you when I held the one-on-one meetings that I had with you during my transition period. And I shared with staff essentially the point that you heard them during the many meetings where they came and spoke very passionately about the impact of the collective bargaining process on morale. And I have indicated to staff that I got a very clear message that once our MOUs were executed, I needed to focus on rebuilding morale in this organization. And so in that vein, we have a host of initiatives that we are undertaking this year. We are launching a new training and development program. We are launching comprehensive employee onboarding and career coaching all this year, and I've been sharing that with staff in these meetings that I'm having. We also are launching a malpractice insurance working group. This working group will achieve the statutory requirement that we study the viability of mandatory malpractice insurance in California. That report is due to the legislature in March of 2019. We will be having the first meeting of the working group here in LA on Monday. And last but not least, this year, we have got to launch the upgrade to our Oracle ERP system. This is not sort of a sexy out-facing system, but it is the heart and soul, the bones of our organization, our procurement, financial, HR systems. We are upgrading them this year. So the good news that I want to share with the board is in these meetings, I'm seeing that our staff is really energized and engaged. I think we have sort of successfully moved past the troubles from last year. Staff understand our strategic plans and where we are trying to go as an organization. And most importantly, they understand where they fit into that strategic plan and how they are part of the engine that's going to help drive our success. I think we are really working as a team, really a leadership team, and really all of staff together as a team to create what's called the secret sauce in organizational development lingo. And that is where your employees are engaged and as a result put in that extra effort to really bump up your productivity and to help you maximize your performance as an organization. So that's the good news for the board. On the flip side, and as Michael mentioned, we really can't reasonably be expected to continue at this pace and with this level of quality without additional resources. There is only so much that I can ask staff to do, and I see Vanessa looking over at me as she's one who she gives me this message as well frequently. The reality is we must fairly compensate our staff including providing a reasonable level of retiree health benefit to all of our staff. We must have enough staff to carry out our important public protection mission. And we must have the resources that we need to invest in the capital and IT infrastructure that keeps our engines running. So 20 years without a licensing fee increase is absolutely too long. And as Michael mentioned, when the political environment so allows, it will be critical for us to garnish a significant and meaningful increase in our licensing fee. That's my remarks for today.
Do we have any questions of the executive director? Okay, that takes us to our consent calendar. Is there any desire to remove anything from the consent calendar that has not already been withdrawn? So if you want us to pull Lisnick, okay, we'll pull number 12. Anything else that needs to come off consent? Okay, everything on consent is deemed approved except for Lisnick. May I have a motion on the Lisnick appointments? Recognizing that there are a number of vacancies on their board that will be named after we take this action, and that we've directed Donna to come back to us in May, having had some dialogue with Lisnick and with COAP, and perhaps with the Unity Bar, which is an umbrella group of bars in Sacramento, to see what we can do to enhance the diversity of that board. May I have a motion? So moved. Jim Fox and Joanna Mendoza with a second. Is there further discussion? Please call the roll.
Broughton?
Yes.
Chen? Fox?
Yes.
LeBron?
Yes.
Lee?
No.
Manning? Mendoza?
Yes.
Petula?
Yes.
Salad?
Yes.
Spector? Yes. Stallings?
No.
Steinbrecher?
Yes.
Stevens?
Yes.
Okay, that takes us to reports of board committees. When you make a report for your committee, that constitutes a motion for each item, and that motion, because it comes from committee, does not need a second, and we can go right to discussion and roll call after you present. So Mr. Lee, for the RAD committee. You've got the confirmation, the resolution supporting the confirmation of our chief trial counsel. Yes, thanks.
Thank you, Michael. What's the resolution? There it is. Okay, thank you.
There we go.
So at our RAD committee meeting yesterday, we had a discussion relating to our support for Steve in the pending, as of yet, unassigned date for his consideration to become the chief trial counsel. And you see before you the resolution proposed reflecting our support for him.
And that constitutes a motion. I'll lead the discussion just by noting that Steve has had a rather whirlwind 10 months. He joined us in May at a time of great change in that office. He has dug in deep, has created an atmosphere in which the employees can heal a little bit for the traumas that they have been through. He's gone through quite a struggle to fill the vacant positions in his department, and he's now close. He has listened deeply to the many folks who have an opinion about what he should be doing. Not all opinions consistent with one another. And in particular, he has found ways to reach out to the many communities in California that don't speak English as their primary language, that have not been treated well by so-called notarios and other immigration consultants. He's in dialogue with INS to get into the detention facilities there, to speak to the detainees, to make sure that they know that the resources of this organization are available. He has revamped our unauthorized practice of law unit in impressive ways, has shut down a couple of, quote, law practices, unquote, and has reached out and rebuilt our partnerships in the unauthorized practice of law space. And for all of those contributions, I say thank you, and that I, for one, am quite pleased to see this resolution before us. Is there further discussion? If not, may I substitute the roll call? Actually, we need a new roll call, because I think this one may have a slightly different outcome than the last.
Broughton?
Yes.
Oh, do you have a motion? Oh, you don't.
We don't.
Broughton?
Yes.
Chen, Fox,
Yes.
LeBron,
Yes.
Lee,
Yes.
Manning,
Yes.
Mendoza,
Yes.
Ertula,
Yes.
Selig,
Yes.
Hector,
Yes.
Stallings,
Yes.
Steinbrecher,
Yes.
Stevens.
Yes.
And the one item we have for the programs committee has been withdrawn, but did you have anything else that you wanted to report, Joanna?
No.
Okay, were there any of the other committee chairs have something they wanted to report at this time? Okay, that takes us to item 701 on our agenda, which is amendments to the strat plan. And I believe DAG is going to present.
So the amendments to the strat plan, and I think this is going to involve something of a discussion. This is the third consecutive meeting of the board at which we are looking at the strat plan. In January, we had a great deal of discussion in laying down the foundation of the strategic plan. In February, we refined the strategic plan and finalized some important pieces of it, but goal 4 regarding access to justice remained. And yesterday during the program committee meeting, we had a detailed discussion of goal 4 and items that should be contained under the objectives for goal 4. So what we have on the agenda today is a relatively simple addition of items from the information technology strategic plan, which we would like to add to the strategic plan and to finalize it, and then additional items that I think need to be discussed and finalized, because coming out of the programs committee meeting yesterday, what we had was a lot of interest in pretty much everything that was on the agenda. Leah took some of those comments, did some working with the language, sent them to me. I did some additional wordsmithing and trying to fit items in based on the discussion that we had. But I think that for today, what we want to do is we want to review each of the items and then confirm that this is what we want to include in the finalized strategic plan that we will lay down to guide the work of staff in the coming year and beyond.
So let's take this in chunks. And the first chunk is on the screen in front of you, and it's 3, what I understand to be fairly non-controversial items to continue to enhance our technology. Is there any desire to discuss any of those 3 items? Seeing none, why don't you take us to the next chunk of content?
So the first of the next chunks of content is simply a modification to one of the goals 2, objective D. And I should also note that the entire plan is probably going to be renumbered and relettered as we insert all of these items, so don't get too hung up on the fact that it's currently goal 2, objective D. It likely will change, but that item, there were some suggested edits made to that, which is shown in the red line up above in terms of providing a specific end date for that, and also to ensure that that work is done in consideration of supporting the goals of increased access to legal services or for other reasons, and implement needed changes there.
So we'll take that one in isolation. This is to review the special admissions rules through an access to justice lens. Is there desire for further discussion of that element of our strat plan? Seeing none, takes us to the next block.
So now we're into the meat of the discussion with regard to the access to justice goals that are under goal 4 here. So I think we need to take each of one of these separately. So by December 31st of 2018, review the loyal referral service certification rules with the goal of increasing access to justice.
And the existing rules are somewhat dated and reflect at a time when our primary concern was regulating this kind of information service to protect clients. We want to update those rules to reflect the big changes in technology that have happened in the last 20 years, and to balance client protection, which remains an important goal, with client access to legal services as well. So that's A. Is there any further discussion? Go ahead.
Let me just also add that A is currently on the programs committee work plan without the language around access to justice. So by taking this action, the board will bring this work plan item into the strategic plan as an objective, and then of course add the access to justice language to it.
Any desire to discuss the LRS matter further? Okay, item B. This is to study online service delivery models, which is the Rocket Lawyer Legal Zoom AVO marketplace, through the lens of both access to justice and consumer protection. It's got a date on it of 2019, so we're teeing that up for year 3 of our 5-year strat plan. Is there discussion on this item? Okay, silence being consent, will take us to C, which is to, Renee?
Is that a study we're gonna do internally? It just seems like a really long time. Like almost 2 years.
Why are we putting it off? The thinking is that it's going to require a task force. That task force is going to be a fairly substantial commitment of staff time. And our thinking is that plate is full this year. So we did put it out a year for that reason.
It's not that it wouldn't get started, so again, I think the thought is that it could get started in the 4th quarter of this year realistically. I don't know how we do that without a task force. I think we had some discussion of that yesterday, simply because we need to bring in a number of voices into the conversation.
Yeah.
So that's,
But isn't there, I mean, it seems like there's some groundwork needed that a task force isn't gonna do, right? Like, there's a lot of these operations, they're all quite different. It seems like we need someone to do some kind of baseline analysis of just what's out there and the different models so that we really understand before we start talking to people. I mean, can we authorize, I don't think it would cost a lot to hire a consultant to do that. I don't like to spend money, but I don't see that we have a lot of resource around people who really understand that world. So could we do that to at least get it started? I mean, I just feel like this is a big deal, and it concerns me to have something on there that we're going to get to in 2 years.
sure, I think that's fine. And again, this is an end of due date, not a date that we're gonna start. So maybe that should be clarified, that all of this, including the type of research that you're describing, and then ultimately the generation of recommendations would be completed by then. But we can clarify that it's gonna start this year, and certainly we can look at hiring a consultant to begin the research and sort of fact-finding work.
Yeah.
So do we want, I'm glad to say that commencing in 2018 and concluding no later than December 2019, just start that with a commencing 2018? Does that meet your need? Okay.
But I'd say as soon as, I don't know, I want it December 31st.
Right.
I would note that during the programs committee discussion yesterday, I think it was a consensus that we needed to begin that as soon as we possibly could. No decision was made as to when that was, but we all agreed it needed to happen very quickly. So, we can work with staff figuring out what steps we can take and when we can do it. I think everyone agrees with your sentiment on that.
There's enough going on out there that's surveying. I mean, there's so much going on out there. The venture capitalists have a label for this space. It's called legal tech. I'm following a blog that describes the use of artificial intelligence and blockchain in the legal industry. And most of the time, I can't make any sense of even the headlines, much less the stories.
Yeah.
So there's an awful lot going on out there.
Yeah, there is, given, as I said, so I just don't know that we even have the resources internally of who can even figure all of this out, time-wise, or even just kind of really understanding that world enough. So anyway, I'd like to see us get started on it, and then the program committee or whoever can develop a plan what we do next.
More discussion on the legal tech piece? Let's take us to C. This is something we've committed to previously, which is to do a California Justice Gap Study. Is there more discussion of that item? Okay, let's take us to the next chunk of content.
Actually, Michael,
Go ahead.
I do have a question. Leah, are these tasks budgeted? Do we have resources to carry out this, what we're approving today?
No, they're not budgeted. Do we have resources? Well, we have a general fund reserve for general fund funded items. Some of these things do not need to be funded by the general fund. As I mentioned yesterday, we have discussed trying to procure grant funding for the Justice Gap Study, and I had indicated that we may have some alternate internal non-general fund funding sources for that. So no, we haven't costed all of these out yet. I think we will be able to find room in our budget to do the things that we've talked about so far and that are outlined on the screen.
Okay.
Yes, sir.
For the post-study, how does the work that we've done prior to the bar mesh with this proposed project? Because I know there's been a number of task force related to identifying, addressing gaps in legal services, for instance. And we've often, and we spent 2 years in the governance task force talking about needing task force.
This is somewhat particular. We received a report, I think when you were down with the flu, from the National Corporation for Legal Services on a study they had done to measure what the unmet needs for legal services are using the polling process. Who needs a lawyer, for what purpose, at what time, and how are they meeting those needs? Are they getting information from friends? Are they going to the law library? Are they getting a lawyer? Are they doing without? And what we're proposing to do is replicate that study specific to California to get a baseline of quality statistical data that then we could use to inform our policymaking in the access agenda, and that our partners in the access world could also use that data for grant applications and to direct it on resources. So it's intended to be a statistical exercise at some level. So in that sense, we've never done this before.
Thank you.
More. Okay, Dag, you want to take us to the next one?
We finished C there?
I believe so.
Okay, D. So then the final one here relates to exploring options to increase, the final one here relates to exploring options to increase access to the licensing of paraprofessionals, limited license legal technicians, and other paraprofessionals.
So that one has a 2020 date on it, so we'll be following the legal tech one. And so this year is the needs survey, next year is legal tech, and the year after that is limited license professionals. Is there discussion on this item? Is that the last chunk of content there?
That is.
May I have a motion to adopt the resolution incorporating all of these components?
So moved.
So that was Alan and then Brandon for the second. Is there further discussion? May I substitute the roll call? Actually, I think we've got somebody absent. Does that change it? We need to call somebody absent? Mark got away.
Oh, okay, yeah. Crawford, Chen, Fox,
Yes.
LeBron, yes. Lee,
Yes.
Manning,
Yes.
Mendoza, Portula,
Yes.
Sella,
Yes.
Spector,
Yes.
Stallings,
Yes.
Steinbrecher,
Yes.
Stevens.
Yes.
That takes us to item 702, which is the fingerprinting topic, which we've heard a bit about and will no doubt hear a bit more about. And this is to be presented by Carolina Almirante and Suzanne Grant. Susanna is in the air, so I think you got to fly solo, Carolina. Dag is going to support it. And Jade.
I'd like to be co-pilot here.
Okay. Welcome.
Hi, good morning. Can you turn the microphone on?
Yeah, and if I may just kick off real quickly. So Suzanne wasn't
I
able
think
to.
you are far from your mic or have an inferior mic.
Testing, 1, 2. Testing, testing, that does not seem to be. So just as a quick overview on this item, we took the proposed rule for fingerprinting of re-fingerprinting of attorneys out for public comment late in 2017. We brought the proposed revisions to the board at the January meeting. At that time, the board approved sending those proposed revisions out for a subsequent 30-day public comment period. Those comments have come back, and we have now some minor revisions to the proposed rule, which we do not believe need further public comment, and then a proposed implementation schedule. The comments that came back from the second public comment period were largely the same as the comments that we got from the first public comment period, so there's very little new there. So I'm not going to get into that, partly because there's not much new there, and also because that's the type of detail that I would prefer to have had Suzanne here to discuss and get into. But if there are questions about that, we can begin that conversation. But I would like to turn it over to Carolina, who's been working in my office on the implementation piece. And the implementation piece involves cross-divisional work with our Attorney Regulation and Consumer Resource Group, our IT group, working with the California State Department of Justice, working with the Office of the Chief Trial Counsel to figure out what we're going to do with all of these fingerprints as they come in, how we're going to route them, and also looking in particular at this issue of what the timing is that gets us to December 1st, 2019, with all of our existing active licensed attorneys in compliance with this rule. And so these are the details that Caroline has been working on, and I will turn it over to her to discuss those.
Thank you, guys. So again, I am a program analyst for the Office of Research and, the Office of Research and Institutional Accountability. And much of my work, as Dag mentioned, since I started mid-January, has been supporting the implementation of the refingerprinting of licensed attorneys. In the agenda item today, we had provided you a proposed notification of penalties as well as reminders that will be going out to impacted attorneys. The key things we want to highlight for you is that we will be providing initial notice to attorneys once the rule has been approved, and at that point, a series of reminders will go and follow in stage 2 and stage 3. More specifically, there's a penalty that will be issued in May 2019, as well as a second penalty that will be issued in August. The majority of those impacted by the schedule will be those active attorneys. Staff have taken consideration those attorneys that may become active at a later point and not meet the requirement necessary to receive a subsequent arrest notification service, and so we've made additional points regarding extensions for them as well. And this is the proposed schedule that we would like the board to approve.
So the recommended action has 4 components. We are forwarding to the court for adoption the rule of court that appears in attachment C to the staff report. We are adopting a schedule that's described in the staff report. We are adopting a proposed policy for fee reductions for those who are qualified for fee scaling for their license fees. And then we are sending out for public comment another rule that addresses the, what does that rule do? That addresses non-compliance with the fingerprinting requirement. So those are the 4 components of the staff recommendation. Is there a motion?
Well, can I ask a question, Carly? Now, what is the proposed due date? So I see that penalties begin to be assessed May 1 of 2019 under this proposal. So our due date then is April 30th, 2019.
That's correct. It's, that's the starting point in which penalties will begin.
Okay. And the other thing I wanted to make sure that the board was clear regarding was what staff's proposal is on the application of our fee scaling provisions for fingerprinting. So we're essentially recommending that we apply the same fee scaling provisions that exist for the licensing fee for fingerprinting. So there are those that get the 25% reduction of their licensing fee and those that get 50% reduction. And so we're proposing to apply those same principles here. So I want to make sure the board was aware of that as well.
And what do we expect that to cost, and where do we expect that funding to come from?
So currently we identified approximate of 128,000, and as identified, it's supposed to come out of the 2018 and 2019 budget.
So it's a one-time cost of $128,000 to reduce the fingerprinting fee for those attorneys who are qualified for fee scaling.
Yes.
And that would come effectively out of our general fund.
Right. To 2018 and 2019.
So we spread across 2 fiscal years.
So, Brandon Stalling, so logistically, how would that look? Would there be a list of vendors that work maybe at a reduced cost scale?
No. So to try to figure out how it's going to work, what we did is we decided that we would pay 100% of the cost up front. So the form that will be on my paper profile for these attorneys will include a code, I guess, that indicates that we pay the full cost of DOJ and FBI processing costs. Then when we do the next assessment of the licensing fee for these attorneys, we will add in an additional assessment for either 75% of the DOJ FBI processing cost or 50%. So we front load pay up front, and then we're going to recoup it on the back end through the licensing fee assessment.
And is that just for those who are qualified for fee waivers or for everybody?
Just for those who are qualified.
And for lawyers who don't qualify for a fee waiver, they would be paying?
Yes, they're going to pay 100%.
And I assume they pay it in 2 ways. When you go to your local UPS store to get fingerprinted, you pay a fee for the service they're providing. And then there's another fee that's paid to the bar at a different time to get those fees processed. Or is it the money you pay at the UPS store all you pay?
It's all up front.
Got it. Okay. Brandon, did you have more?
And then who would make that decision on the fee waiver aspect of the plans? Is that a staff decision or is that a board of trustee decision?
Well, I think we're gonna assume that the people who qualified for the fee scaling for their 2018 licensing fee, for example, that would be the population that we would assume is gonna qualify again. So there probably will be some folks that are new that aren't currently receiving a fee waiver. We'll have to come up with some approach for those individuals.
More discussion?
Did you want to say anything, Dag, about the hits that we have been getting out of it for the small population for whom we have subsequent arrest notification service?
They're kind of a mixed bag at this point, because what we're looking at, and we don't know exactly which of these, we would have to do more research to determine where we're getting the hits from, but recall that we submitted about 3,000 fingerprint cards that had been kept on site here for as long as 3 years, and we submitted those back in last summer. So some of those people have since been admitted to the bar. We're getting the initial background check on those people now. So when we look at some of these background checks that we're starting to get in, some of them involve, I think the most typical thing is maybe a DUI of some kind, or a substance, some sort of controlled substance in either another jurisdiction or in California, but most frequently prior to admission to the bar. So in these cases, what we're going to need to do is we're going to need to do additional research to determine whether this was part of the moral character evaluation and whether it was revealed at that time or not. There have been a couple that we've seen that have involved hits from DOJ subsequent to admission to the bar, and those we're still working through, and I'm talking with Steve about how exactly we deal with those, because there's a 30-day period, I believe, that attorneys have to self-report. So I think we would certainly want to ensure that that period runs. If it's anything that's come in and is fairly recent, we would want to ensure that that period runs before we even then forward it on to OCTC for any action that they might take. So I think that there's a fair amount of work that needs to be done in this area. However, knowing Carolina, she may have already done some of this work, so I would at least give her an opportunity to share what her thinking is on the hits that we've been seeing.
With the logic that's being developed right now for OCTC and what cases actually go to them, we're thinking about in our pre-screening component, getting IT support on identifying dates and matching that information with what's in OCTC's database, and as well as admissions, to understand what information was disclosed during moral character and after that point. And so we're hoping that we could screen the process much more efficiently and quickly, because 3,000 is a lot too.
You know, I've been out there preaching the virtues of fessing up about your conviction before we find you in a variety of settings, including the newspaper and this room and elsewhere. Has anybody done that? Have you seen any noticeable uptick of people reporting stale convictions?
I think OCTC could have done that. That would go there. But we are planning to issue the FAQ next week, assuming the board approves the rule today. When the rule is submitted to the court, all attorneys in the state will receive an FAQ via email that just sort of is encouraging self-reporting and reminding them very succinctly of what the reporting requirements are.
So a couple facts I'd like to see reported in the paper shortly are that the deadline is going to be April 30th for everybody to get fingerprinted and submit their prints to the bar, and that anybody who chooses to reveal to us a prior conviction before that time can expect more lenient treatment from OCTC than those we have to find.
I don't know if our chief documents is going to go to that latter piece. I'm looking at it because we've been having these discussions, and I'm not sure.
I'm not making any promises. I just know that most rational justice systems take cooperation into account. It certainly won't hurt you to come forward voluntarily, and it will hurt you to be found out later. Please.
I've dealt a lot with doing background investigations and doing the fingerprinting and having people. I mean, what's going to be in place? You said, there may be leniency, because you're going to find there's going to be a lot of people that are going to fail. That are going to take you're going to do the fingerprints. It's a general rule of thumb is, anywhere from 20%, plus 20%. You'll find something, and hopefully you give them that chance before to get the fingerprints done to say what they might find, and then you can do mitigating circumstances depending on what it is. But what do you do with the ones that don't, who really think that you will never find them? and that, oh my God, that was so long ago, or the ones that claim they forgot, that they spent 2 nights in jail. Could they be disbarred at that time? I'm just sort of serious, I'm just wondering, you know, if they're already an active attorney, and that comes to front, you know, what happens to them?
You want to have OCTC comment on that?
Yeah,
Steve, you want to come up to the mic? I should mention that Araya has told us that if you assume the level of criminality that the medical profession experiences, where they have been doing these checks over the years, and compare them to the self-reports that we have received, there's somewhere between 3,000 and 9,000 lawyers with convictions that we will learn about in this process. So call it 6,000. Steve.
Thank you. So we continue to explore exactly what the process will be. There are some issues with particularly the time frame, depending on when that incident occurred, what the impact is going to be, and who's going to take it. I don't believe that we can invalidate the admission automatically through admissions or whatever else. So I do think that it will have to be some sort of a disciplinary action on our side in order to accomplish that. However, it will require, or it will depend on whether there's a continuing obligation, depending on when that offense occurred, to continue to report. If, for example, they've already been cleared and then the incident occurs, is different than if they're continuing to go through the process and the incident occurred.
So some of the things I imagine you're going to take into consideration when deciding whether to discipline and at what level are how fresh the violation is it old and stale, or is it recent? How serious the violation is it a first-time DUI, or is it aggravated assault? And whether they disclosed or not. That would seem to me to be at least 3 characteristics that would be rational for you to take into consideration.
I think in general that's accurate, yes.
And remember, I mean, one of the things we've been talking about is sort of alternatives to the traditional discipline approach. This may be an opportunity for us to better engage and partner with the lawyer assistance program, where we see that substance abuse is an issue, to perhaps work with our Office of Probation a little bit differently. So I think there are some opportunities here as well for us to have some new approaches to dealing with these folks, depending on really OCTC's assessment of whether or not discipline is the appropriate pathway, or we may look at some alternatives that address sort of the underlying behavior, protect the public, yet allow us to access some of the other options that we do have here at the bar.
Joanna.
Steve, there's no statute of limitations, so to speak, on a failure to report, is there?
No, I don't believe so, because that would most likely fall into the category of the SBI or State Bar initiated, and there is no rule of limitations on an SBI. However, the distinction is the obligation to report. 60680 requires an attorney to self-report an indictment or information being filed against them charging a felony. Is subparagraph 4, and then subparagraph 5 is the conviction of a felony or of a misdemeanor involving a number of different things, essentially implicating the practice of law, whether it's a crime where the victim was a client or it otherwise involves moral turpitude. And of course, the definition of moral turpitude in this context is different than in the other criminal contexts where it's for impeachment as a witness or things like that. It really, in this context, is defined as impacting their ability to practice law, honesty, veracity, things like that. And so those are the only self-reporting obligations. They're somewhat different than the reporting obligations for the courts or for prosecutors to report when they file charges against or have dependency of the action against an attorney. And frankly, at some point, we may want to look at making those reporting requirements more aligned, whether it be altering the attorney reporting requirements, frankly, to make it a little less confusing, because there isn't a there is certainly no itemized list of all crimes that constitute moral turpitude for purposes of attorney discipline. And so it's frankly quite confusing. And so, or whether it's changing the reporting requirements for the courts and prosecutors to more closely align itself with the reporting requirements for attorneys. But that's a discussion for another day.
Have we seen any uptake in reports since this discussion began?
I don't have that information before the board. My apologies.
Thank you, Steve. More discussion from the board of this item. Sean.
So I have a question about the change to the provision about attorneys who are residing abroad. So it's been revised to.
So this is on page 3 of the staff report.
It's on page 3, right. So there was, basically there was a concern expressed that some attorneys who live in certain foreign countries might find it too difficult or expensive to be fingerprinted, et cetera. And so this was liberalized a little bit, but I just wonder if it needs to be tightened up. So it's now states that attorneys who make a certain showing will be exempt until they return to the United States for 60 days, which is a pretty long time. I'm wondering if it should be shorter. And I'm also a little concerned about the situation where attorneys residing abroad, but it's going back and forth, and comes back for 55 days and practices law, comes back to the States, practices law here for 55 days, and then returns to the foreign country and, does this repeatedly. So it may be sufficient just to assess this maybe at the end of next year to take an inventory of how many foreign attorneys remain unfingerprinted due to this exemption and then address it a little bit. I just want to toss it out because I think there's potential for abuse.
Okay. Do we have any idea how large this population is? How many lawyers we have who are actively practicing with foreign addresses?
It's approximately about 1,400. We were looking at those stats yesterday, DNI.
Do you want it, do you want it to be like 30 days? Or really, it sounds like the duration requirement itself is problematic too, because people can come in and out.
I think so, and I'm not prepared to provide language because I think it would be a little bit complicated.
Yeah.
I would be inclined to reduce this to 3 days, and also it needs to be, it's not clear when this takes effect, so is it, if they're residing, is it April 1st, when does this all start? So I think maybe it could be some additional consideration for this, or it could be tabled in an amendment later. But it's a small population of attorneys, and so.
We need to get moving on this to get this done by the deadline.
So I don't think it's obviously not worth holding out there
All
right
right,
now.
so maybe you could just direct us to report back on how that would be going.
Yeah.
Foreign attorneys.
Okay. More discussion from the board? May I have a motion for the 4 recommendations from staff?
So moved.
So we have a motion from Alan, may I have a second? Second. We have a second from Jason, is there further discussion? May I substitute the roll call? Oh, sorry, Bridget, please. If there's any other member of the public who wants to speak after Bridget, please let us know. Got it.
Good morning. For those of you
I
that
think
are
we need to be a little closer to the mic.
Sorry. Is that better?
It is, yes.
I'm Bridget Grammy from the Center for Public Interest Law. I know there's some new trustees, so just to briefly let you know who we are. We're an independent academic center of advocacy and research at the University of San Diego Law School. And I just wanted to let you know that we really do support this rule. And I know there's been, you've heard the public comment where attorneys are concerned about having to absorb the cost on their own. And while I definitely understand that, I think it's more important for public protection that the attorneys do pay for it. The reality is, for those of you that are new and haven't really, been part of all these discussions going forward, or in the past, the money is going to either have to come from increased bar fees, or it's going to have to be diverted from the discipline program, which I really don't want to see from a public protection standpoint. So CPIL really does support this rule as it's written, and I encourage you to vote for it today. Thank you.
Thank you for being with us.
I just want to add something about her talking about having the lawyers pay for it themselves. Most people who work for school districts and they all have to pay their own fees to get the fingerprint done. That's not uncommon for people to have to pay their own fees. So I wouldn't think that the lawyers, I guess there's something if they're, whatever you have where you can get a discount kind of thing, but But I agree with her, they ought to take is the regular public or that are working someplace where they have to get their fingerprint stuff, most of them pay themselves.
The problem, to answer that, the problem is that we already did pay for that when we applied for the bar. So we all paid our fingerprints, and then there's been some mishaps not having to do with the current administration where those have been destroyed. So we're having to pay again, which is the problem.
Okay.
We should probably.
Everybody needs to hear that offline.
No worries.
Yeah.
Any further discussion from the board? Please call the roll.
Thank you.
Thank you. Yes. I believe the motion was Alan and the second was Jason.
Broughton,
Yes.
Chen, Fox,
Yes.
LeBron,
Yes.
Lee,
Yes.
Manning,
Yes.
Mendoza. Yes. Petula,
Yes.
Savage,
Yes.
Spector,
Yes.
Stallings,
Yes.
Steinbrecher.
Yes.
Stevens.
Yes.
The motion carries. That takes us to item 703, which is an exception to the CalPERS 180-day waiting period to appoint a retired annuitant. Vanessa.
So you heard the commendation for Pat Lee, and we would like to, after Pat retires, we would like to bring her back as a retired annuitant to assist with the transition of her work. And she has all the qualifications for being a retired annuitant, but in order for us to bring her back sooner than the 180-day current requirement waiting period, the board has to pass this resolution to, which is set forth in attachment A, to exempt or waive the 180-day wait period.
Is there any discussion, Joanna?
So moved.
We got a motion from Brandon, is there a second?
Second.
Second from Alan. Joanna?
Okay, thank you. Vanessa, how does the bar determine which former managers need waivers and which ones don't?
I think there's two questions there.
Yeah.
Everybody who's a retired annuitant who comes back on payroll needs a waiver. That's a law, that's a PERS regulation. Second question is, who do we decide we need to come back? That we can't see their departure on their preferred retirement date without a transition. And that's a business issue depending on who they are and how long it's going to take to fill their vacancy and what we plan.
So every retired needs a waiver if we decide that we need to have that.
I'm the one retiring through the CalPERS system.
Right.
Okay.
Once you're drawing a pension, you can't draw a paycheck without a special status. Any further discussion on this item? May I substitute the roll call? The matter is deemed approved. This takes us to item 704, which is the Client Security Trust Fund mandated report to the legislature. Our presenters are Donna Kirkowitz and Lori Mellock. Both of them are present. Neither of them stuck in place. Welcome. And Justin's appearing as their wingman.
Justin always appears as our So we are presenting today for board discussion.
The mic, I think.
How's that?
That's better.
We're presenting today for board discussion a draft of a legislatively mandated report on the Client Security Fund. The report contains a list of options for addressing the current shortfall, and we are seeking direction of the board if any of these options should be eliminated, if we should maintain them in the report, or if they should be crafted in the final version of the report as recommendations. In January, the trustees heard as part of the discipline system training about the work of the Client Security Fund and the resource challenges that the fund is currently facing. We are all, trustees, staff, and the legislature, necessarily concerned about the time it currently takes for the Client Security Fund to pay out uneligible claims. As a result, as part of last year's fee legislation, the legislature directed us to study the Client Security Fund, to look for process improvements and internal funding sources, and try to funding sources to try and resolve claims within 12 months. Specifically, the legislature directed us to do a thorough analysis of this Client Security Fund, to examine the the bar's oversight of the fund to ensure that we have the most efficient and effective structures in place in order to operate, to include a look at the ongoing needs to be able to resolve applications within 12 months, to determine what efforts could be taken to increase collection of the money that's currently owed, so we would be able to pay out more claims, to do an analysis of whether funds can be whether bar funds can be redirected to the client security fund, including an analysis of whether executive salaries and benefits could be reduced in order to better fund the client security fund. And then only after looking at all of those options to report if an increase in licensing fees would be necessary in order to enable the fund to pay out claims within 12 months of receipt.
We just wanted to briefly explain again the purpose of the Client Security Fund so that you know what we're dealing with here. I'm Lori Malak, the manager of the Client Security Fund. As you know, the fund reimburses applicants for losses caused by the conduct of dishonest licensed California attorneys. In 2006, that was also amended to include foreign legal consultants and attorneys registered with the State Bar under the multi-jurisdictional practice program. So at that year, they were added to be covered by the fund, but no dues or licensing fees were ever charged to them for the fund. So you'll see that later. We'll be discussing that. The fund handles different types of dishonest conduct. It can be misappropriation of a settlement funds, failure to refund unearned fees, conversion of money or property, or borrowing money or from a client, or asking them to invest with you without the intention of ever paying that money back. Those are the basic types of losses that we cover currently. And as we've discussed previously also, the Client Security Fund does not move forward with an application until the rule that we have requiring status of the attorney. And in our rule, that means that there's discipline of the attorney, that the attorney's been disbarred, is deceased, or has become a judgment debtor or convicted of a crime for something like fraud related to the matter. So as you see there, we have the discipline requirement. Most of our attorneys fall under that rule under what we refer to always as the discipline requirement. That's they've either been disciplined on the specific matter that the application is based on, or the attorney has been disbarred or resigned from charges pending. That's the main type of cases that we handle.
And we're getting additional microphones so we can stop moving the microphone. So I just wanted to give you a quick overview of the funds that are currently available to fund the Client Security Fund program and those clients who have been victims of their attorneys. There's $40 attached to the licensing fee for all active attorneys. It has been at this level of $40 since 1989. In 2006, an additional fee was added for inactive licensees of $10 as part of their licensing fees. As a result of these two assessments together, it yields approximately $8 million annually for the Client Security Fund. $6 million of that roughly is spent on the payouts or the reimbursements to the clients, and $2 million roughly for administration of the program, the 8 staff that we have, and other expenses. So how do we spend that money that we have, that $6 million for payouts? The average payout is roughly $7,000. The maximum payout per applicant was set initially at the fund's inception in 1972 at $25,000. It was increased in 1982 to $50,000. And then effective January 1, 2009, after we had an actuarial study performed and determined that we could support an increase, we increased the maximum payout per applicant to $100,000. Unfortunately, our crystal ball was a little dusty at that time, and we were unaware of the staggering increase in applications that we were about to receive as the loan modification crisis hit. In 2008, we received 825 applications to the fund. 2009, it went up to 3,028. In 2010, it hit its apex at 3,875 applications, so quite a jump, and we did not have any way of knowing at the time that we increased the amount of the payout to $100,000 that would be happening. Prior to that, historically, the fund had operated within budget and resolved applications within a 12-month period. But the growth in applications eroded the fund balance to more than we were able to process and pay out in a given year. We are paying out the maximum amount of funds that we have. So taking a look at what the inventory is that we currently have and what it would take to be able to fund to pay out that inventory. We currently have roughly 3,400 applications that are pending. Looking at the amount that is claimed on those applications, it's just over $52 million. We've taken a look to see, well, how many of those, if we were to pay on them, how many of those are in fact eligible, i.e. this discipline requirement that Lori talked about has been met. We're looking at about $31 million in applications that could be paid out today if we have the money. Looking at the average amount that we pay on the claims that are submitted, pay roughly 45% of the claims that are submitted. And so looking at that, we'd have a one-time funding need of roughly $14.2 million to be able to pay out on the current applications. Now, on the consent agenda that you approved earlier today, you approved a budget amendment that directed $800,000 to the client security fund, so we can take that $800,000 off that $14.2 million need. So that's our on.
So it's 13.6.
Yeah, it was $1 million, but 200,000 is for indirects. So 800,000 will go for payouts.
So 13.4.
So that's a one-time need in order to deal with the applications we currently have. The number of applications and the amount and the amounts of the amount claimed on those applications has begun to stabilize, and we have come out of the increases that we had seen from the loan modification days. It is estimated that the annual amount that would be paid out on new applications on a going forward basis is $7.8 million. As I mentioned before, under the current funding model, the ongoing funding that's available for payouts is about $1.8 million shy of that, at $6 million. As a result of identifying that need and in response to the direction of the legislature in pulling together this report, staff identified various options that could increase the amount that's available for payouts and enable more timely payouts. Some of these options require statutory changes, some require rule changes, some require neither. There are pros and cons to these options, but we wanted to be thorough in laying out the options for board consideration. So the first option that we have is to reduce the maximum payout from $100,000 back to $15,000. Again, the cap had been set at, maximum reimbursement cap had been set at $50,000 in 1982 and increased in 2009. If you look at attachment D in the materials that we provided to you, which looks at the climate protection funds in 37 other states, or 36 other states plus California. California is one of 13 states with $100,000 or more as the maximum payment cap. 6 of those 13, in fact, pay more than $100,000. On the other hand, if you look at California's Victim Compensation Fund, the cap that they have set for payments to victims of crimes is $70,000. So that is one option that the board could consider as reducing the maximum payment amount. The board could also consider just cutting the amount that they pay to 50% of all the qualifying losses. Instead of paying the amount that we would have otherwise paid, we could reduce that to 50%. The current rules of the Client Security Fund allow us to limit payouts if financial circumstances of the fund would require that. Another thing that we could do to limit the amounts or the types of applications paid is limiting payouts to California residents or to matters that have a nexus to California. Some states do only pay their own California residents. California pays the victim of any licensed California attorney, or as Lori mentioned, the foreign legal consultant or participant in the multi-jurisdictional practice program. The California Victims Compensation Fund, as a comparison, like some other states, only pays out if the crime occurred in California or the victim is a California resident. So that would be something that we could do. Over the past 3 years, it looks like we're averaging about 20% of the claimants are non-California residents. So we are talking about some money here. But if we were to think about sort of who are the people who might fall into this pool, often these are the folks who were the victims of the loan modification scams, where you have attorneys who are advertising over the internet to people who live in a variety of states. And if they were only licensed in California, then those victims do have no other recourse other than the California Client Security Fund. We could also imagine a situation where we're dealing with people who were the subject of immigration fraud by their lawyers. Believe the lawyers were moving their claims forward, processing their claims. They discovered that the lawyers, in fact, had not filed anything, had not proceeded, and they are deported, and they would have no recourse in this situation either.
Some of the other options that we laid out for you are on this slide. As you can see, one of the things that we could do would be to impose income eligibility requirements. We currently do not capture information regarding the income of the victims who apply to the fund. So we don't know how this would affect the fund and how much money we might save depending on what the cap was set at in terms of income. But it's something that we could consider having some kind of a means test, essentially. Another thing that we could do, right now the fund covers applications that involve loans and investments, where an attorney asks somebody to invest in a company that they claim they're forming and then steals those funds. There's really no company. These tend to be larger types of losses. You could say that it's not necessarily the type of loss that you would expect someone going to their attorney to suffer, but they do suffer those. I mean, we see different types of cases like this. But they are large losses. It's something that we could look at in terms of limiting the type of cases that we cover. We could also have a special cap on cases involving unearned fees, as opposed to just straight misappropriation cases where the lawyer gets the check and then keeps the check, which is clearly a theft. In these cases, you could say that we could have a cap on fee cases where the attorney is still getting fees from the person. Most of these cases do involve losses that are $10,000 and under. We do see that there are some cases that go higher than this. We do question those a little more. Why were you continuing to pay somebody if they weren't doing work for you on something like this? So it's an area that we could look into more. I was looking at the statistics on this. We have most of our cases, and this isn't broken down by which cases are requesting fees and which are requesting other types of losses, but of our 3,400 inventory, 2,900 are requesting under $25,000. And then of that, if we looked at 10,000, it's 2,400 cases are under $10,000 in what they're requesting. Those tend to be fee cases more than like a PI settlement or something like that. So it's something that we could look at. I think there's about 18.1 million requested if we look at the total that are requesting under 25,000. So that's another area that we've been looking at for you.
Another option for limiting the amount of applications paid out on, one exception to the discipline requirement that we have is if your attorney is deceased or has already been disbarred, we're not requiring you to file a complaint with the Office of Chief Trial Counsel because they wouldn't obviously process that complaint. We certainly could say we're not going to waive the discipline requirement in those instances, and we could require all applicants to have filed a complaint with the Office of Chief Trial Counsel about the attorney in order for the Client Security Fund to consider it. A downside to that approach is it does seem to benefit or harm those people who have selected what turned out to be sort of the most deceptive of the attorneys because they did not learn of the misconduct or the misappropriation of the funds until it was too late, and we would have foreclosed the opportunity to file.
Sorry, is there, you were just throwing out some statistics about size. Is there, I can't find here a chart with the distribution, so like the value of claims by size? So like when you were talking about reducing the 50,000 to 25, like how many cases and how many dollars would that affect?
As we get toward the very end of the PowerPoint, Justin will be going through what the fiscal impact is of each of these options.
No problem.
Next, we're going to turn to options that we have developed that could generate additional revenue. Lori?
So one of the things that we could look at is to stop including the CSF assessment in the fee waivers or fee scaling of the licensing fee. So basically, we just exclude the CSF $40 from the waiver or scaling. Some of this could be handled possibly by the board on the cases that they waived it on, but this might also need legislative statutory change for some of those waivers. So it's something we can look at, and again, Justin can say how much that might add to the fund. Another thing that we would like to do is to add the CSF assessment to the fee for registering as a foreign legal consultant or multi-jurisdictional practice program participant. By statute, CSF covers losses that would be caused by these registrants, and so we think it makes sense to add that fee on to what they pay right now.
One of the other things that could generate additional revenue is adopting a rule that would permit monetary sanctions to be imposed where there's an order of the Supreme Court imposing suspension or disbarment on a member of the state bar. We are required by statute to adopt such a rule, and we are working on that. We'll be presenting a rule in coming meetings to RAD and to the board. The statute provides that sanctions in this case would, in these instances, would exceed $5,000. Could be up to $5,000 for each violation, capped at a total amount of $50,000 per attorney who is suspended or disbarred, and that money would be earmarked for the client security fund. Additionally, we could pursue legislation to improve collections, and you'll be hearing about some of this as part of the legislative priorities item later. Our record on collections is not what it should be. And there are a variety of things that we can do to improve collections of our outstanding discipline costs, of the restitution that has been ordered by the Supreme Court that we have paid out to victims on, and also for CSF payments. And a couple of those things that could help improve collections is if the discipline costs and the CSF payouts could be part of the FTB court-ordered debt collection program. It would require a statutory change. We have had preliminary conversations with some staff at the Franchise Tax Board and they have expressed preliminary interest in extending the program to include the discipline costs and the CSF payouts. One of the other things that we would like to do, we currently cannot share the Social Security numbers of the licensees with our private collection vendors. And as a result, it really has hindered the ability of the collection vendors to do things like wage garnishments, to do skip tracing, because you can't necessarily locate and make sure that you've got the right person. So statutory change that would allow us to provide Social Security numbers, the full Social Security numbers in some cases, and at least the last 4 digits will certainly help those collection vendors be able to do better collections. Another thing we could do that we could contemplate to generate additional revenue is adding voluntary contributions to the CSF as part of the licensing fee statement as an opt-in or an opt-out. Similarly, how we've got we've got the opt-in for contributions to the Justice Gap Fund or other legal services programs. One of the things that certainly is a fear is that if you add another contribution, You're not going to increase the overall amount of contributions you get. What you'll be doing is diluting and directing existing contributions. And so it could result in moving money from one box to another and creating problems in other areas as well. We also looked at the extent to which we could transfer funds to the client security funds from other places in the bar. There was a statute that was enacted as part of last year's fee bill, which authorizes the transfer of excess lawyer assistance program funds to the client security fund. These are funds that are not needed to fully support the program. If you look at the fund condition, we currently are projecting a reserve balance or fund balance at the end of 2018 of $3.5 million in the lawyer assistance program. However, that does not take into account expenditures that would be necessary to implement the newly enacted lawyer assistance program strategic plan, or recommendations that we have received from clinical experts on ways to improve the lawyer assistance program, which includes a variety of outreach to really grow the program, and a preliminary estimate of the costs of implementing the strategic plan and those recommendations from the expert were roughly $150,000. It is a preliminary estimate, however, but if you subtract out that and subtract out a couple of other items which are needed to support LAP, we're still looking at about roughly $2.7 million in reserve balance. We had a conversation with the Lawyer Assistance Program Oversight Committee this past weekend, and they are very concerned that at this point we don't really know how much it would take to fund the Lawyer Assistance Program if it were operating at full capacity, if they were able to successfully do the outreach that they need to do, not just what would it cost to do the outreach, but what would it cost to run the program with that outreach being successful. Additionally, one of the items on the Appendix I review that we mentioned earlier, one of the items that is being looked at is whether the State Bar remains the proper place to host the lawyer assistance program, or if it's something that should be contracted out, go out on its own. To the extent that ultimately there's a conclusion that the bar is not the place to host, then taking some of the reserves at this point could impact their future ability to sustain themselves if they needed to use those reserves to go out on their own. So that's some concerns that the Oversight Committee had that I wanted to make sure to express.
And another option that we're looking at is reducing the CSF minimum reserve amount. We could amend the reserve policy so that we're limiting the minimum reserves to a percentage of what CSF administrative costs are and not what our total amount that we pay out on cases is. And that's something that the board and finance could work on to come up with what they feel comfortable and making sure we're still obviously complying with our fiduciary obligations to the fund.
The next bullet on this slide talks about identifying savings from reductions in staff compensation. Justin will turn to this issue in just one moment.
And of course, we're always looking at just ways that we can improve our process to make it more efficient and make sure we're handling things in the best and most economical way that we can. So we've recently had 2 new staff positions added that will help us to more quickly resolve those cases that come into the fund but are clearly outside of our jurisdiction. We're trying to let people know that they don't qualify if it's clearly something that doesn't qualify more quickly on in the program. We're also working with people who are trying to obtain the documentary proof on cases more quickly in the process also, so that if the case isn't qualified, we can let them know, or it gets in line more quickly so that when we can handle it, we are ready to move forward on it. We're also, as part of the Appendix I review, looking at changes to the role of the Client Security Fund Commission that might be able to help reduce the time to pay out. Currently, all cases on which tentative decisions have been drafted go before the Client Security Fund Commission. The applicants and the respondents then have the right to object to those decisions, and then the case will go back to the Commission for review of objections if there are objections received. So one of the things we're exploring is the time that we could save if the Commission only reviewed the cases on which objections had been filed, and could possibly save around 2 months in moving cases forward, depending on, the timing of our meetings and how we handle planning our calendars for those meetings. So we're looking into that as well as something that just help us to keep cases moving along in the system. I think this is you, Justin.
Thank you. Justin Ewert, the principal analyst with the Office of Oriah. We were tasked to conduct an executive compensation study, and we contracted with CPS-HR, the person that the consulting agency that performed our classification and compensation study in 2017. We were asked to compare only executive branch agencies, and that was a request by the legislature. The consultant indicated that the agencies selected were inapt comparisons to the bar, and the reasons for this were location. Also, these other agencies have HR and general services that rely on that are outside those agencies, where we have all of those agencies in-house. It is not aligned with the 2017 compensation study reflected in the MOU, and that's because the 2017 the study had 16 agencies of various cities and counties within San Francisco and Los Angeles, also judicial branch agencies and superior courts. It included a full articulation of new compensation structure based on revised executive salaries. So the results of the executive salaries were put into our current salary structure, and so supervisors were 10% above the line staff and 10%, and executives were 10% above that. So it resulted in significant reductions. The implementation of the 2017 study would have saved the bar about $0.6 million. Now, the bar decided not to cut existing salaries when we implemented the 2017 study. We instead red circled those employees, but new employees were hired at the new salary structure. Of that $0.6 million, about $71,000 was executive staff and $480,000 was all other staff, confidential and represented staff. Implementation of the new 2018 study would save the bar $8.1 million. The executive salary would need to be cut by $1.8 million, and all of their staff would need to be cut by $6.3 million. This option to reduce executive pay is not really feasible. And an example of that is in OCTC, we have an assistant chief trial counsel. The supervising attorney would be making 33% more than the assistant chief trial counsel under this new salary structure. Another way we wanted to compare ourselves to other agencies in the study, and so we took a look at the percentage of executive salaries versus regular salaries, regular bargaining unit salaries, and we compared favorably when we took a look at that. The bar spends about 15.8% of total salaries on executives and 84.2%. The other agencies vary from 18% to 20% on their executive salaries, and so we actually spend less than all the other comparator agencies except for the Attorney General's office. I want to mention that the 5 comparator agencies were the Attorney General's office, the Department of Business Oversight, and we chose this because it's a similar sized agency with locations in Los Angeles, Sacramento, and San Francisco. The Medical Board, the Department of Consumer Affairs, and those were the main comparator agencies. As another ratio, we looked at the executives to staff. So for the Department of Consumer Affairs, they have 1 executive for every 9 staff. At the State Bar, we have about 1 executive for every 10.5 staff. The Medical Board and the Department of Business Oversight both had around 1 executive for every 7 staff. So we have a much higher staff to executive ratio. And so if...
Right, I think your bullet point actually says the opposite. I'm not sure how others read that. You may want to just clarify that for
Yeah, it says staff
posterity.
executive, and it should say executive staff.
Yeah,
Okay,
yeah.
thank you.
You would not want that to be misread.
Yes. And so an alternative of reducing salaries would be to cap the amount of compensation or the amount we spend on executives or the ratio for executives. That would take into account that we operate in places that where the cost of living is significantly higher than Sacramento or other areas. So the next slide, this shows the options of all the things that were presented by Lori and Donna. At the top, the reducing the maximum payout, so if we capped it back down to 50,000, it's about $500,000 a year. If we only pay California residents, it's about 1.2 million savings annually. Change eligible losses is about 0.8 million. All three of these options do have an impact on the victims. The transfer that Donna talked about is the 2.7 million. This is a one-time infusion because LAP does not run a $3 million overage every year. Denying the fee waivers would be about 0.1 million. Having multi-jurisdictional practice and foreign legal consultants pay the fee is about 0.1 million. Reducing the required reserve to only administrative costs would be about 1.4 million. And then all these other options at the bottom, we don't know exactly how much they would generate because we've had poor collection results in the past with disbarred attorneys, and some of the other voluntary contributions, we don't know exactly what the impact that would be on the other voluntary contributions we currently have. So as we indicated before, the 14.2 million, today you have already adopted a budget amendment of 800,000, so that takes this, currently it was 35 in addition to the 40, so 75 total. With that budget amendment, it comes down to 71. So we've reduced that the need by $4, so it would only be $31 extra. Also for the ongoing need, because yearly we only have $6 million to pay out, but we anticipate $7.8 million coming in, we would need an additional ongoing need of $10 for every active attorney and $1 for every inactive attorney. I have various options depending on what we select to implement that reduces that total number. And so I can comment if there are questions on this time. We can probably go back to the other slides so we can see that.
Yeah, let me suggest this. I think we should take a short break. When we come back, we have two things to discuss. One is we need to approve the report, which is due to the legislature in 6 days. The report also needs some refinements to reflect feedback we've had informally from the legislature. So I'd like a volunteer or two who's got time in the next 6 days to review what Leah and her team come up with. Secondly, I'd like to walk through all of the options that have been presented to us and sort them effectively into two bins. Those that we would like staff to develop for further discussion and those we're not prepared to entertain at this time. We can't take any action on any of these options today because this has been teed up as a discussion item, but staff can develop them for more discussion later.
Move the reserve.
But we think we can give direction for that action, but it would still come back at a further meeting.
The board would have to change the reserve policy
Right.
for us to do that.
So let's take a 5-minute break. We'll come back and start marching through these options.
understand that that's horrible, but we'll get to the case
Okay, let's get started. I think the easier of the two things to discuss is the report itself. What I'd like to do is see if there's a comment on the report, and then I'd like 1 or 2 volunteers who've got some time in the next 6 days to serve as liaisons from the board so we have some time to review the refinements that will be made before we submit. So is there a discussion of the report itself apart from these options? Do I have a volunteer or two to work with Leah on the final version of the report?
And maybe, Michael, just to help encourage volunteers to clarify what I really think we need to do is the options section of the report, which is maybe 10 pages, just 10 pages. But particularly, we need to build out a section that talks about other possible general fund support for the client security fund, and really frankly why we don't have other options in the general fund to redirect the client security fund. So that's really the piece that needs to be fleshed out over the next 6 days. So it's not as daunting perhaps as the entire report.
Anybody have some bandwidth this week? Okay, I'll do it, and we'll find somebody else at lunch with a little arm twisting, and Debbie will do it. Okay, great. So what I'd like to do now is march through the options that we've presented and sort them into the ones we want staff to further develop and those which we're not prepared to pursue at this time. Now, I don't want to step on the board's discussion. I do want to be respectful of my role and yours, but I do want to frame this a little bit because it's somewhat sensitive in terms of legislative attention to this issue. So we've got a one-time problem of $13.4 million, and we have an ongoing problem of $1.8 million. We're running an insurance fund here, and the premiums aren't covering the loss. Logically, there are 2 ways to fix this. One is to pay less money out, which has a burden on the claimants, and the other is to bring more money in, and if that were easily done, we wouldn't be having this conversation. The bringing more money in has 2 pieces, those things we can do ourselves, and those things we need legislative assistance on. We should be thoughtful about reducing payments to claimants. But personally, I would not rule it out, particularly when we're talking about claimants who don't have a tie to California, and those claimants who are quite sophisticated folks who are engaging in sophisticated investment transactions with people who happen to be lawyers. To put it bluntly, if we've got a limited resource and we've got to spread the pain, my heart doesn't bleed for rich people who aren't from California in this setting. Having said that, I'd like to walk through the options and let the board express its views about which options we are prepared to entertain further discussion of, recognizing we're not making final decisions, and those that we prefer not to address at this time. And one last gratuitous comment, and I'll get out of your way. The LAP has its own constituency, and that constituency is of some significance to us. And there is legislation in the building at this moment because of that constituency. And so I, for one, would be cautious about taking resources away from LAP until its circumstances set. End of my discussion. Why don't you tee up the first one for us, Donna?
Certainly. So again, the first one was to reduce the maximum payment from the cap, the maximum amount that can get paid to an applicant. The cap was set in 2009 at $100,000. As I mentioned, California is one of 13 states noted in your attachment D where the maximum cap is $100,000 or more.
Joanna?
Can you go back to the screen that showed what the fiscal impact was of each one of these options? 'Cause
I want to run the discussion from this page because it gives you more detail. But why don't Justin can tell us for each one what the cost is.
This is about $500,000.
It would be helpful if we could just look at it for a minute.
Sure.
So I could know, is that a lot on the chart? I don't remember.
Okay, sure.
You can also see the options in the report beginning on page 17.
Well, we can use this as a checklist, but you'll have to explain what your shorthand references mean because they're a little opaque.
Yeah.
My sense is there's 3 options on this one. Status quo, 50 grand, or 70 grand, which is where the victim's compensation fund is. Speaking just for myself, I think it's too soon to make this large a move at the expense of claimants.
Could I ask, how many payouts since 2009 have reached the 100,000 maximum?
Just a reminder to use your microphone for the web.
Oh, I'm sorry. Jim Fox, and I was wondering how many payouts since it went up to to 100,000 in 2009, how many have met the $100,000 cap?
I don't know the number, but I would say that we easily have 20 to 25 a year probably that fall into this range. And these are the people who've suffered the biggest losses. Somebody stole the entire probate, estate from someone who passed away, or in some of the loan mod cases, what we had was somebody, if you put all of the proceeds from your house into my trust account, and then we'll find a way to negotiate something else. I mean, there's the schemes that they come up with obviously can be devastating to people. And so these are very bad losses for people who may have lost kind of everything they had. Also, we tend to find a lot of these cases involve, just through my memory, thinking of the cases I've handled, elderly clients.
Renee and then Jason.
Sorry, just on that, just my question before, because I don't think it got answered as I thought. So that was over 100,000? How many, because this is taking it from 100 to 50, right? So how many cases is that? So it's $500,000 of payout. That's based on how many between 50 and 100, and is that similar to what's left in the pool, or is that just from this year?
The $500,000, I think, was what we figured we had paid out last year. Justin, was that from 2017 numbers?
That's an annual savings of $500,000.
Yeah.
Okay, it's not what's in the pool, right?
No, because in the pool particularly, I think Lori, remember there's 2017 was a larger year because there was one particular attorney who went off to Costa Rica, and there was several $100,000 claims from one specific attorney.
We're getting a number of PI cases against a certain attorney that are pretty large losses that have started to come in the end of last year, or through last year, and now it's continuing to come in.
I'm sure you have this data, but again, I just think the distribution of what's in the pool and what you pay out would be really
Make a note to bring that to the board when any of these options comes to the board.
We have requesting between $50,000 and $100,000. We have 285 open applications right now.
Out of 3,400.
Out of
Yes.
3,400.
Out of 3,400.
So it's like 7%.
Jason and then Todd.
Jason Lee. So if the exercise is to put this in one of the buckets, I would say for consideration. I'd like to see the idea of a maximum payout with a means test as well, because I think you can balance the impact on the client, on that client's economic situation. That may be a fair way to do it rather than a straight reduction, no matter the circumstance of the client's situation.
So you would put a means test only on somebody that is possibly qualifying for the maximum? Would that be the idea?
I'd be open just to see how a means test would apply to putting maximum thresholds on recovery by a client.
One of the things that we also need to think about is how, to whom would the new rules apply, right? If you're reducing the payout from $100,000 to $50,000, there are a couple of ways to do it. One is any application, whether we have it or not. So anything that's decided after X date, that's the rule. The other way to do it is to say CSF already has jurisdiction over claims that total about $31.6 million. Right? Those are the cases that are pending that they have jurisdiction over. You could say that the rules that applied as of the date they had jurisdiction should be the rules that apply, and then you wouldn't feel the effect of this change from $100,000 to $50,000 for quite some time.
I think that level of detail is something we should take up when the idea comes back. Just to get through the list we got today, I'd like to keep it at a higher level of generality. I think Todd has the floor now.
I would support Todd Stevens. A one-time lap transfer of, say, $500,000, and if lap doesn't...
We'll get there. We're just talking about the top line. We're going to march through these one by one.
The top line?
Yeah,
Oh.
maximum payout.
Oh, I don't have a comment on that.
Okay, any further, Joanna?
I'm very hesitant to address that. There's so much we'd be adding to the analysis if we were getting down to the, fine stuff. I mean, hearing about seniors getting ripped off, they're some of the most vulnerable in our society. People who've had personal injury claims are very vulnerable in our society. These are attorneys that have ripped people off a huge amount, and we're talking about reducing their ability to recover, and that really troubles me. So I, personally, it doesn't add much, and I'm just very hesitant to put it in the bucket for consideration because of that.
Yes, sir.
Josh Brusula. I'm also very hesitant. It seems that, I think you said there were 13 states. We have in California some of most expensive cost of living. We obviously made the choice at 100,000 to reduce that as a first option, or even without looking at all the other options concerns me.
Okay, what I would suggest is that we take a series of straw votes as we walk through this list. So does somebody want to move putting this on the to be considered list?
I so moved.
Is there a second?
Second.
Okay, so we have a motion by Jason, a second by Renee to keep this item active for consideration in the short run. Let's take the roll on that.
Broughton,
Yes.
Chen, Fox,
Yes.
LeBron, yes, Lee,
Yes.
Manning,
Yes.
Mendoza,
No.
Petrulla,
No.
Zelik,
No.
Spector, no, Stallings,
No.
Steinbrecher,
No.
Steven.
No.
Okay, that one is not on the list for short-term consideration. Let's take us to the only page. Do you have something to say?
I just want to clarify, it's not on the list for consideration, meaning staff isn't going to work it up further. I would suggest that we do retain it
Oh, of
as
course.
an option in the report.
Sure,
Okay, all right.
sure, absolutely.
All right, we're not
Yes.
changing any of those.
Okay, we're not going
All right.
the legislatures know everything we looked at, but the ones that we're going to look at in the short run, these ideas don't go away forever. If we find ourselves 6 months out and this fund is still in a hole, we've done everything we've done, and there's still more that needs to be doing, well, these ideas are going to come back. Okay, Sean.
Just a general comment, which I didn't fully appreciate till the discussion earlier, that figures we're looking at for these options only reflect future annual savings, as I understand it. And they don't correlate with the one-time $14 million shortfall that we had in December. So I think in the final report, it would be helpful to have, to provide the information of if we were to make these changes retrospectively, the pending applications, how it would affect the $14 million one-time shortfall. Does that make sense?
Yeah.
Okay, the next suggestion is label here only pay California. Can you add some water and stir and expand that a little bit?
Yeah, and actually, one that didn't show up on this chart was a different approach to reducing the maximum, so I just want to make sure that we fully understand where that goes on your list. And that was reimbursing only 50% of the qualifying losses. So if we would otherwise say you qualified for $25,000 based on everything we have, you'd get paid $12,500.
My guess is that those of us who didn't like the cap going down from 100 to 50 don't like the idea of spending $50 either, right? Got it. Okay, so both of those ideas are not on the short-term plan.
That is what I assumed, but I like to make sure.
Hell no.
The next was limiting payouts to California residents or matters with a nexus to California. Again, some states do only pay their residents. California pays the victim of any licensed California attorney.
Help me understand better what nexus to California means. If somebody's with an irregular immigration status in San Diego, gets ripped off by their lawyer and find themselves with a regular immigration status in Tijuana, is there not a California nexus because they were in California at the time they were harmed?
It would seem.
Okay.
It would depend how we create the rules on this, so we haven't looked at that more closely.
Because, again, I don't want to step on the debate here, but I think limiting our proceeds to California makes sense, but we need to have a sensible definition of what it means to be California.
I will say in the loan modification cases, the respondents were advertising on the internet and had clients all over the United States. So that's the big area where this really came up.
Right. But Joanna?
If that's the case, I mean, and we're pretty much past the loan modification, But I don't see this going forward being as big an issue as it has been. If the attorney is licensed in California, we have a responsibility, you know, the harm they're causing to the public. We don't define our mission as the public only being in California. So again, I hesitate to do it, although I would be curious if we took out, if we added some more qualifications. For example, if the attorney wasn't licensed in any other state, or they had to go to that state before if that's where the activity occurred, I'd be open to that. But if the attorney is only licensed in California, I'd be hesitant. So I'd say let's put it in a bucket, get some more details on what the possibilities could be, and that's where I'd be inclined to go.
Lori and then Jim.
I will just say that where we know that they're licensed in another state, we do work with the other funds, and we try and refer people to that state if we can. So we do that as much as we can.
The concern that I have is that people who live in New York may have litigation in California. They can only be represented by California lawyers, and that California lawyer can cause them great harm. The fact that they were required to have a California lawyer should not exempt us from making them whole if in fact they have been the victim.
And that touches on my question, what's a California nexus?
That's a nexus.
I think that's a nexus, because litigation was here, fine. But if you've got a lawyer who lives in Truckee and practices in Nevada and California and screwed somebody over in Douglas County Superior Court of Nevada, I'm not sure I want to pay on that.
Right.
Brandon?
Brandon Stallings, BNP 6140.56 says, refers to losses caused by the dishonest conduct of members of the state bar. And so I think that the statute is pretty clear as to what we should be reimbursing.
But we may be talking to the legislature about what the statute should say. Is there more discussion on this idea of requiring some sort of California nexus? We ought to have a motion to throw it into the short-term list.
So
Jason moved, is there a second?
Second.
Stacy seconded. Call the roll.
Broughton. Chen. Cox.
Yes.
LeBron. Yes. Lee.
Yes.
Manning. Yes. Mendoza.
Yes.
Bertula.
Yes.
Selig.
Yes.
Spector. Yes. Stallings.
No.
Steinbrecher.
Yes.
Stevens.
Yes.
Yeah, that one carries. That takes us to.
Sorry, just one substantive comment on the last item. It seems to me that some of the situations that would be excluded for people who are not California residents and for which the matter has no California nexus would involve the unauthorized practice of law. And so I just throw that in the hopper as a policy consideration, whether situations in which the California lawyer is engaged in UPL in another state,
Right.
that should be a unique category of those. Just something for consideration.
Staff should have that in mind as they work this up for us. Okay, that takes us to change eligible losses. Can you expand on, remind us what that means? Is this to eliminate the sophisticated transactions of lawyers involving debt and the like?
Right, this would possibly eliminate or otherwise limit, based on our current rules, covering loan and investment losses.
So there are some lawyers who are expert in the finance law, and they have a business model by which they identify opportunities for arbitrage, where they can run a little investment fund for their clients and make an unusual rate of return until the regulatory agencies catch up and close that loophole, and then they find another one. So they're basically running private investment banks and law firms out of the same office. The people they do business with can invest very large sums and can lose very large sums. And I, for one, I'm not sure we should be insuring that.
We do have special rules for loan and investment cases. So the loss had to arise out of it in the scope of the attorney-client relationship. It had to be a pre-existing attorney-client relationship. So we have had people come to us and say, respondent X had an investment firm, and I went there, I gave him $100,000, and he also said, don't worry, I'm a lawyer too, so your money will be safe. In those cases, the commission would likely deny under our rules because he wasn't already your lawyer and then said, let me take your money from you. You went there and then you said, oh, by the way, I'm a lawyer. So that's what we have right now. The kinds of cases that are the difficult ones of these are where, again, he handles a PI case for someone. Oh, I see you got $2 million in your settlement. I handled that for you. I bet I can get you a nice increase on your money by investing it for you. Why don't you let me have it? And then they steal the $2 million. So in that case, you went to him as a lawyer, he got your money for you as your lawyer, he got the check as your lawyer, and then he says, I'm going to keep it and invest it for you, and steals it all. Those are the cases that are the more tricky ones under this rule, where he really is just outright stolen your money, and that's, I think, what the rule is intended to cover more than the type of case that you raised.
So I think for me, this option, the attractiveness of this option really depends on the details. I really need to understand what I'm screening in and screening out.
Yeah, and I think that the commission, in its discretion, is doing that. So, we raise this for you as an option, but I can assure you that our commission is very careful with these kinds of cases and looking at them and making sure that we're covering what really is the practice of law and somebody taking the money versus just a sort of investment scheme where very sophisticated people, we often worry also if the applicant is sort of involved in what could be the scheme as well.
Right. Do we have a consensus to leave this one in for short-term consideration, or do we want to exclude this one? Or do I have a motion either way? Motion to include. So Jason has moved to include it. Is there a second?
Sure. Include or
Include. And Todd has seconded it. So Jason's motion, Todd's second. There's no more discussion. Call the roll.
Broughton,
Yes.
Chen, Cox,
Yes.
LeBron. Yes. Lee,
Yes.
Manning. Yes. Mendoza. Yes. Pertula.
Yes.
Kelly.
Yes.
Spector.
Yes.
Stallings.
No.
Steinbrecher.
No.
Stephen.
Yes.
That one carries. LP transfer. Is there a desire to include this in the short run, or is there a desire to leave this off the table in the short run?
I would like to read on this. I think we have a really big decision with the appendix on review, and that feeds into this so much that I think it's premature for us to be considering this one at this time. Based on my knowledge of the LAP and how things are operating, I personally think they would be better off not affiliated with the state bar any longer. I think it would be a more effective program. And I believe Patrick Krill has indicated there are some benefits to that as well. So I'm very hesitant to mess with their funding, knowing that what the California Lawyers Association is going through, all the startup costs are significant. So I'd say hold off for now.
Todd?
I agree with everything that Joanna said, except I think they can spare it. I think it's spare 500,000. They can spare 750,000. I think 2.7 million, even if they go on their own, is more than enough.
So, Sean?
Well, I think we should leave this option on the table, but contingent on deciding an actual decision about what's going to happen with the LAP and a workup consistent with Todd's suggestion, even if they were to leave what the starting costs are and whether there's money that could be used. So it's not an all or nothing proposition.
So the idea is to develop this idea further with more information for the board about how much money they can spare and what they might need for the transitions that are under consideration. Ron, is that workable direction to staff, or is that too early?
It is understandable direction to staff. I am truthfully uncertain that in our ability to ascertain what those startup costs might look like, because I think there are a number of costs to consider. There are various options that it might look like. We can certainly undertake the exercise and report back if we are unable to do so. To do that calculation, we'll let you know.
Do I have a motion to include it in this form?
But my concern is that we're just going to continue to study this LAP. We've been doing this since I've been on the board. This can't go on forever. And we can't depend upon lapsed decision to leave 2.7 million just sitting there, in my opinion. For something like the Client Security Fund, I wouldn't have rated that for anything else but client security.
And the LAP Oversight Committee, as I mentioned, did talk about this at its meeting this past Saturday. They'll be finalizing the action taken on that item on a call that they're having, I think, next week after next. And the idea was to present a policy to their recommendation for a policy to the board at the board's meeting.
This is one of those recurring but unfortunate moments when you're pitting one good cause against another, and none of us is good about that. Do I have a motion to include or exclude this option?
Move to include.
So Jason has moved to include, do I have a second? Todd has seconded it. Are we ready to call the roll?
Broughton,
Yes.
Chen, Fox,
Yes.
LeBron,
Yes.
Lee,
Yes.
Manning. Yes. Mendoza,
No.
Petula,
Yes.
Salad,
Yes.
Spector,
Yes.
Stallings,
No.
Steinbrecher,
Yes.
Stevens.
Yes.
That one carries. That takes us to deny fee waivers. Can you remind us what that means?
So this would be to exclude the $40 CSF assessment from any fee waivers that the board considers.
Or fee scale.
Or fee scaling, sorry,
Do
both.
you want to flip back to the pages? I wasn't suggesting that we only ever do
Okay.
this. I just wanted to get a reminder where everything. Yeah.
It's one more back. There, Thomas.
Yeah.
Okay. So the idea is we've got a class of attorneys who don't have to pay their full fees because of their income. They've been getting all of this $40 waived. The question is, should we make them pay the whole $40 or some part of the $40?
They haven't been getting all of it waived.
Okay, they're not.
They're getting a portion.
They're getting a portion. So it's scaled in the same way that fees are scaled.
Right.
Got it. Okay. What's the will of the board, Jason?
Move to include.
Seconds.
Is there a need for a roll call on this one, or can we do this by consensus? Yeah, I guess I feel a consensus to include this one. Okay. What's next?
Next was the MGP and the formula policy.
And these are people who that we pay claims against them, we're just not asking them for a premium.
Well, I don't think we've ever had an application filed against one of them, but under our rules, if we did get one, we would cover it.
And just, we are going to need to correct the report in two categories of MJP, not all of MJP. It's still, the principle still applies.
If it's me, this strikes me as a no-brainer. We're covering the risk, but we're not getting a premium. Let's get the premium.
Move to include. Yeah. Second.
Is there a need to discuss this further, or is there a consensus? Okay. That one's included. What's next?
Next was reducing the required CSF reserve.
Yeah, the reserve policy by the board is a minimum of 17%, a maximum of 30%. There is an exception for the Legal Services Trust Fund and Equal Access Fund because they pay out large grants and some amounts of bank settlement fund. The board has already approved something. So this would be only requiring reserve for the administrative costs, not including the payout costs. So right now, if you include the payout costs, we have to have $2 million reserve there, where there are people that we're not paying claims on. If you go to 30%, that allocates $1.4 million to be paid out to claimants. So if we're just doing it on the basis of administrative costs, and like I said, we already have an exemption for other funds.
This one strikes me as a no-brainer as well. Is there anyone who wants to discuss it? Okay, that one's included. Go ahead.
Yes, I support it for sure. It correlates with an idea that was triggered by the reference to elderly claimants, because with the delays we're facing now, some of those people will never see the payment. And so I wondered if, either in connection with changing the reserve policy and freeing up that $2 million or whatever it is, or just in general, we should consider some kind of prioritization system that gives preference to elderly people, people who are terminally ill or whatever. Just like in court, you know, if you're elderly, you go to the front of the line for your trial.
If we're aware of that circumstance, and they often will call us and let us know, we do bring that to the commission as soon as we can for people.
Oh, so they do have the discretion to do that?
The commission does have discretion to do that.
Okay.
Sometimes we're not aware, unfortunately, until we take out the file to look at it, and then we do our best to move it, but we do try and prioritize those cases.
Okay, thank you.
Jason.
I'm in favor of including, and I'm sort of racking my brain as to why you would have a reserve based on the claims. And the only idea I can think of is if our priorities change in terms of who is submitting a claim or what we're paying out, not having any reserve would result in sort of perhaps a funding gap.
But we get $6 million in fresh cash every year, and those new priorities could be attached to that new cash.
More discussion of this item? Sorry. I wonder if we ought to take this up sooner rather than later. In other words, certainly it should go in the report, but I wonder if we ought to put it on our agenda to actually execute this.
Yeah, I think
Get
it's
that
gonna be
nice
worked out
done.
fairly quickly.
This is one that can go on the board's agenda in May.
Okay. Any further discussion of this item? So by consensus, this is coming back to us in May, probably on consent. Okay, monetary sanctions.
Well, I think we're kind of getting.
Yeah, we're at the point of where it's unknown for the rest.
Okay.
So we were up to means test.
A means test means that we would do income testing for the applicants and provide less insurance to the well-to-do than to the down and out. And are you thinking of that as scaling the percentage that they get paid or imposing a cap on the wealthy, or what were you thinking? Or have you not gotten to that level of detail yet?
We haven't gotten to that level that if this were an avenue the board wanted us to pursue, then we could come up with different options. But we're not going to know what the yield is going to be because we are not asking victims at this point what their income level is. And there would be administrative costs involved in presumably doing some income or asset verification.
Yep. So, Sean?
So I would generally be disinclined to adopt this, but it seems to me that this correlates with the investment scenarios that you discussed earlier, and so it may be that you could consider it only in certain cases doing a means test. So we're talking about sophisticated investors, qualified investor under the SEC who's very sophisticated or has a high net worth. But in general, I wouldn't support this.
More discussion on this one? Jason's moved to include it. Is there a second?
I'll second.
Mark is seconded it. Further discussion? May I substitute the roll, or do we want to call the roll?
I don't support it.
Okay, let's call the roll.
Broughton,
Yes.
Chen, Fox,
Yes.
LeBron. Yes. Lee,
Yes.
Manning. Yes. Mendoza. No. Petula,
Yes.
Selig,
Yes.
Spector,
Yes.
Stallings,
Yes.
Steinberger,
Yes.
Stevens.
No.
Okay, that one carries. And that takes us to cap unearned fee cases. So this is when clients have paid a lawyer a fee in advance of receiving the services, and never get the services, and these can be fairly high dollar accounts. So we would have a cap on these claims alone. That's the proposal.
And most of these claims have been under $10,000, but there are certainly a number of applications that are higher than that.
And I would think you're probably looking at more well-heeled folks who can cut a check for 30 grand for a retainer.
It can be criminal defense cases.
Ah, got it.
So sometimes it's grandma paying for grandson.
Right. Okay, Sean?
So I don't quite understand why we would distinguish this. If a lawyer is taking money for services and doesn't provide them, that's equally culpable with other kinds of theft.
We were just trying to raise all options. If you're looking at, it is still a straight out theft if they take the money and don't do any work for it, that's correct. But if you wanted to look at it slightly differently than a case where they receive the settlement check and keep that, which the client had no control over. There was just a slight difference there. And again, we're just trying to raise all options to consider.
Let me ask you a question. So just to follow up, so you had alluded earlier to clients who, so there may be scenarios where like the client pays $20,000 for an advance fee, no services provided. You had alluded to other situations where the client, we could look at the particulars and say this client should have been aware there was a problem and yet kept paying. Does the commission currently have discretion to reduce the claim or deny the claim in those
They absolutely
situations?
do. Yes.
So is there a motion to include or exclude
I
this
move to
idea?
exclude.
So second. The second to exclude, do we want a roll call or people want to come in mind? Let's call the roll.
Broughton,
Yes.
Yes to
Motion
no.
to exclude, yes.
So
Yes, we.
Point of clarification, so does this mean
We're not going to pursue this
we won't
report.
consider it for as an
Correct.
option?
It will stay in the report as an option, but we will not be pursuing implementation of this option in the short run.
Okay, thank you.
So, start again with the roll, please.
Broughton,
Yes.
Chen, Fox,
Yes.
LeBron?
Sorry, I'm not sure I entirely understand this.
Lee?
Yes.
Manning?
Yes.
Susie?
Yes.
Sorry. Mendoza?
Yes.
Petula?
Yes.
Selig?
Yes.
Spector? Yes. Stallings?
Yes.
Steinbrecher?
Yes.
Steven?
Yes.
So we reached consensus. This took us a while. So that one's been excluded from our short-term list. And that takes us to excluding certain categories. Remind us what categories you had in mind.
Yeah, so this was the one where we would, where we could require all applicants to have filed a complaint with OCTC in order for the CSF to consider their application. So if they did not file a complaint, the attorney is now deceased or has been disbarred, and they wouldn't have the ability to file a complaint at this point. This would exclude them from recovery because they had not filed a complaint.
So we're not asking people to file a meaningless complaint as a paperwork hurdle. We're just excluding certain claimants because they have the misfortune to choose an aggressor who died soon.
Well, but let's be careful here. It's not only circumstances where people have died.
Okay.
We have applicants who've been we have attorneys who've been disbarred and clients on other matters not related to the disbarment. We don't require them to file a complaint with TC because they're already disbarred.
Well, you can sense my skepticism. What's the rationale for this?
For what?
What's the rationale for excluding this class of claimants? I'm not. This doesn't speak into me.
But no, it is certainly a fair question.
I move no.
Yeah.
I second that.
Yeah, I think
You
this one.
picked the guy that was so bad that got disbarred that we shouldn't pay you.
This is looking at sort of the vast majority of the cases that we put out on are cases where the attorney has been disbarred and the claimant has the claimant, this particular victim's case was not part of the disbarment case. And so it may be related to the same type of conduct, it may be related to other types of conduct. So understanding that the client with the disbarred attorney is the most common scenario in CSF, that's why we called out this option.
I think we can exclude this one by consensus. Sean, did you have something to say?
I agree with excluding it. However, with disbarred attorneys and resigned attorneys, there is, I think, some utility in OCTC knowing that there were unreported complaints. And so rather than putting the burden on the claimant to file a formal complaint, it might make sense if this isn't already done for the Client Security Fund staff to notify OCTC, we have this claim for misappropriation by a disbarred attorney, we're processing it, we're not requiring them to make a complaint, but it should be in OCTC's file if that lawyer comes back to seek reinstatement.
Would that be added to the probation restitution order if then we pay out?
They're not on probation if they've been disbarred.
Okay.
We share all of our information with OCTC, and if somebody applies for reinstatement, they come to the fund and they ask us for information on everybody we've paid out against.
Right.
Great, thank you.
Okay, so I think that one's on the editing room floor. That takes us to B&P Code Section 6086.13, which I must admit I don't know what it means.
These are the disciplinary sanctions. This is requiring, having us adopt a rule as we are required to by statute to authorize courts to issue sanctions of up to $5,000 for each violation if the court disbars or suspends an attorney.
And this one is actually not an option because we're required to do this. It is an instance of non-compliance by the bar, the fact that we have not implemented these rules. So just want to clarify, we did provide in the report, I think, a good amount of information about the lack of success of our collections efforts. So we don't anticipate this is going to generate revenue, but we are required to adopt rules to implement this provision.
In which case it's on the list without need for further discussion. Jason?
Just point of clarification, is it in a statute that it goes to the lawyer assistant program, or is that what we're
You mean to the Client Security Fund?
Client Security Fund, yes, it is in the statute.
Okay.
And then the other piece of this item was about the tools for improved collection, but as I mentioned earlier, you'll actually be voting on that as part of your legislative priorities, so we don't need to put that on either list.
And voluntary contributions?
This was the opt-in or opt-out on the fee statement.
So this would be including a new opt-in on the fee statement. And that would require legislative authority or no?
Not for a donation.
Not for a donation.
And again, there are certainly some who fear that adding another place for the donation to go does not increase the total yield, but rather would redirect some of the current payments.
So what's the pleasure of the board? Do you want to include this in our short-term strategy or not?
I'm disinclined to include it. We're struggling with our access to justice issues as it is. I would prefer seeing a mandatory contribution being given.
Which we would
Not a
legislative
voluntary. So I understand that, but I don't want to take away from things we're already struggling with at this point.
Is that a motion to exclude?
Yes.
Is there a second?
Second.
Is there further discussion? May I substitute?
My only comment would be that if we are asking or we are giving attorneys the opportunity to choose those programs which they feel are more worthy in their estimation for donating money to, taking away the choice because we want to protect another program may or may not be a wise choice. I'm not particularly in favor of the voluntary contribution program, but I think there is a rationale for considering it.
So I think Joanna moved. Is there a second? Yeah, Jim was the second. Let's call the roll on this one. To drop this from the list for our short-term strategy.
Broughton.
Yes.
Chen. Fox.
Yes.
LeBron. Yes. Lee.
Yes.
Manning.
Yes.
Mendoza.
Yes.
Petula.
Yes.
Seller.
Yes.
Spector. Stallings.
Yes.
Steinbrecher.
No.
Stevens.
Yes.
Okay, that carries. What I'd like to do, I think we're done with this item, is that right?
Well, I think the board has not engaged in any discussion about the salary pieces, and I do think it would be useful just to get some feedback. I just gave sort of a succinct overview. There's a much longer piece on this in the report. Just so the board is very clear, the sort of idea animating this portion of the report and of the study was that conceivably executive staff pay at the bar could be reduced to the level of executives in state executive branch agencies with no modifications made for any other staff or organization. That's obviously not something that we think is viable from a staff perspective, but I did want to make sure there was some opportunity for the board to sort of weigh in on that particular aspect of the report.
Yeah, I'll just say that we did the 2017 class and comp study. We hired a firm that the legislature itself has used for similar work. Their work was credible. It reflected the real marketplace that we work in, and I think we ought to stick to it. And it's easy to say, pay your management less. And we will do that predictably when we're at the table with our union. But it isn't real. You have to attract talent, you have to retain talent, and if you don't give people more pay than the people they're supervising, in the short run you get serious morale issues, and in the long run you get incompetent management. So that's my view. I would invite any others. Jim?
Yeah, I'm adamantly opposed to anything along this line, because in effect what it would be doing is imposing penalties on our management, our executive staff, for the wrongdoing of all the attorneys in California. Why would we do that? You know, it's the attorneys who, as a right to practice, we should be basically indemnifying the fund and adequately funding it. And if that requires an increase, so be it. But you don't put that burden on the executive staff of the state bar when, you know, the studies show that we are not overstaffed with the executives. And if you're going to reduce the salary of executives, who in the world in their right mind would become an executive if they could make the same amount in a bargaining unit without having to deal with personnel issues? And that's the biggest problem, you know, in management, is trying to maintain the morale and a culture of the organization, and you pay for that.
Other discussion on this topic? I would note that the efficiencies in operation that you talked about having the commission not touch every file twice, but only touch the appeals. I think we should look for efficiencies there, and we should pursue them. And if those efficiencies turn into a smaller administrative bite on fund, excellent. Anything further on this item?
No, just to really thank staff. I hope the board can tell from the report that this was a tremendous amount of work to get this done. And I believe, I haven't studied this, but this is likely the first time, at least in many, many years, that the board has been given this level of detail on the client security fund, how it works, who's eligible for a payout, as well as the fiscal needs of the fund. So I just really want to recognize and thank staff, including Dan, who worked on this report. So thank you.
Okay, we have one more item of open session business, which I think we can probably dispatch with fairly quickly. And then what I propose to do is take a 15-minute break to allow folks to get lunch. And then we're going to come back and have lunch in closed session so we can hear from our outside counsel, Joe Ryder and Elias Cava, on the LN cases. So with that, let's turn to our last item of business. Dag, I think you're presenting 705.
Yes, I am. So as with the item on the strategic plan, this item is returning to the board following previous discussion and previous approval of a more limited list of legislative priorities. Back in January, the board approved a number of technical changes to reflect the transition to the new state bar. These changes related to changing references to members, to references to attorneys, changing references to member dues, to references to fees. With those changes in place, since January, we have discussed with our legislative liaison in Sacramento a remaining list of legislative priorities, talked with her about what makes sense, about what the legislature has appetite for. We've also discussed with our members of the board who are our liaisons for the legislative function. And we've put together a more substantive list now of items that we'd like to include on our list of legislative priorities for this legislative session. So the items that are on the list of priorities are grouped under 4 broad headings. One is revenue generating measures. You heard a little bit about this from Donna when she was discussing the Client Security Fund. These relate to amendments to the Franchise and Tax Board Revenue Taxation Code that would expand the court-ordered debt collection program to cover discipline costs and client security fund repayments, that type of thing. Another one of those items under revenue generating measures includes allowing the state bar to provide social security numbers. Donna mentioned this as an issue of skip tracing and other related issues that might allow us to collect a little bit better, but as Leah also mentioned, we have not had tremendous success in collecting, enhancing our collections efforts. So these 2 items would, in theory, help us to begin expanding how much money we actually get back in our collections efforts. Another broad heading here is under the public protection area. I think that these public protection measures also, in fact, reflect some vestiges of the old membership organization, some of which relates to involuntary, inactive enrollment of attorneys and provisions of the Business and Professions Code, which appear to seek more balancing of the interests of the attorneys vis-a-vis the interests of public protection. So there are a number of items here under Business and Professions Code 6007C related to involuntary inactive enrollment. The third category under which we've grouped these legislative priorities relates to reporting requirements. There are a number of reporting requirements that the State Bar has the obligation to fill each year. Some of these are scattered around the Business and Professions Code and the Insurance Code section, the Civil Code, and our current sense of this is that there's not a lot of appetite in the legislature to get rid of these reports, but there may be the opportunity to bundle these reports that staff are scrambling to pull together into the annual attorney discipline report, and that might be a better place to put these reporting requirements. There are also reporting requirements that we're looking at here related to the timing of when specific reports come, to try to rationalize that process so that the timing related to budget items is more in line with when our actual budgeting occurs. And then the final are just some miscellaneous items related to amendments of the Business and Professions Code to allow lawyer assistance program funds to be used for treatment services for those who cannot afford to pay. We're currently prohibited from using lawyer assistance program funds for that purpose. And the final item related to moving the final late filing deadline for the California bar examination up to allow for more time to process accommodation requests. Michael, I think you once referred to this as an example of the micromanagement of the bar through legislation, which it is kind of strange that would require legislative change, but it does. So that's a summary of the items that we would like to put onto the legislative priorities. The one final thing I would just note is that I'm relatively new to this. This is part of my new function, and I'm kind of excited to be seeing how Sacramento works and becoming. I am. No, it's a whole new world. We had a great trip up to Sacramento to meet with legislative staff and to talk with them about what their priorities are and how those align or do not with our priorities. Alan and I talked yesterday very briefly. It sounds like it's a relatively new area for you as well. Alan and Stacy are our legislative liaisons. I think that it's great that we're putting down the legislative priorities, but I just wanted to note that my sense of the matter right now is that this is going to be a much more fluid sort of conversation that we're having with our legislative liaison, with Alan and Stacy, and that we're going to be starting up a bi-weekly conference call with Alan and Stacy so that we can keep them appraised, so that Jennifer in Sacramento can work with them to make sure that we're maximizing our relationship building with our sister branch of government in Sacramento. So I think stay tuned for more. I think we'll also try to find a home for this function within the committee structure. I was talking with Leah just very briefly about whether or not this shouldn't be just a regular item that we're discussing in executive committee. I don't know if executive committee is the right place for it, but I'm looking forward to learning more about it, and I think you'll all hear more about it.
May I have a motion? So moved. Is there a second? Second. So Lee and Stevens, is there further discussion? Joanne?
I just want to point out that the legislative plan to allow LAP funds to be used for treatment could very well contradict the whole concept of taking money out of the reserves, because they don't have any idea what that would cost. And while I support the legislative priority, it definitely is going to have to be worked into the analysis that we just talked about.
There's a lot of moving parts on LAP right now. More discussion? May I substitute the roll call? Please. Call the roll, please.
Broughton.
Yes.
Chen. Fox.
Yes.
LeBron. Yes. Lee.
Yes.
Manning.
Yes.
Mendoza.
Yes.
Bertula.
Yes.
Selig.
Yes.
Stecker. Stallings.
Yes.
Steinberg.
Yes.
Stevens.
Yes.
Okay, we are in adjournment until 10 minutes until noon, at which time we will return to a closed session, and we will not be returning to open session today. So we'll be in closed session to meet with our outside counselors. See you at 10 minutes till.
Ready, Tony? Just get it right at 11.